Hello, my name is Dan Blair. This is the ACLU Missouri Legal Seminar Series. I will be presenting on the topic of Eighth Circuit Standards of Civil Rights Litigation. Welcome to the ACLU Missouri's Legal Seminar Series. My name is Dan Blair, and I will be discussing Eighth Circuit Standards of Civil Rights Litigation today. Here's a bio for me. I am a second-year law student at ACLU Law, and I was a teacher for 8 years before going to law school. Our lesson today will focus on the intricacies of the Eighth Circuit Court of Appeals and civil rights litigation, and we will examine the rights of prisoners in Missouri and the power the Eighth Circuit has over state prisoners. Our learning objectives for the day will be to understand how the Eighth Circuit operates and how civil rights litigation is handled, and understand the complexities of prisoners' rights in Missouri and in the Eighth Circuit generally. So we'll have a few key terms to know. The Eighth Circuit Court of Appeals is the first. The next are a few different tests that we'll have: deliberate indifference, the Turner test, and procedural due process. So our first lesson today is on the Eighth Circuit and civil rights litigation. Here we see a list of the district courts that make up the lower courts for the Eighth Circuit Court of Appeals. These are the district courts in Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota. The principal courthouse for the Eighth Circuit is the Thomas Eagleton United States Courthouse in St. Louis, Missouri, though there are branches throughout the states that make up the Eighth Circuit. The Eighth Circuit will meet from time to time in each of the different states and different courthouses so that litigants do not have to travel all the way down to St. Louis for every case. The way the Eighth Circuit hears its cases is it generally hears cases as a panel of 3 judges. After those 3 judges have heard a case, the Eighth Circuit has the option of hearing a case, what is known as en banc, which is a French word for in bench. And that means that all 11 of the Eighth Circuit judges will hear the case again. This is important because panels of the Eighth Circuit are not allowed to turn over Eighth Circuit precedent. Only en banc rulings can do so, and Supreme Court rulings can also overturn Eighth Circuit precedent. So the Court of Appeals hears these challenges to district court decisions from courts located within its circuit. It is considered one of the most conservative courts in the country, and is made up of majority conservatives. So this greatly affects the ability to bring civil rights litigation, as the Eighth Circuit is generally not overly friendly in comparison to the other circuits to that litigation. So to wrap up this first part, the Eighth Circuit has a great deal of judicial power and has the ability to dramatically affect the individual rights of Missourians. Currently, the court is a majority conservative and rules in accordance with its political beliefs. On to the next litigation and what is going to be the major focus of the series today, which is prisoner rights and the Eighth Circuit. So the ACLU regularly deals with cases of prisoner rights and violations of those rights. So today we're going to talk about some ways to quickly spot what those violations might be and whether or not there are violations at all. So these cases generally are either dominated by Eighth Circuit Court of Appeals precedent or make their way there eventually. So there are specific laws and regulations that govern prisons, and the Eighth Circuit the prisons in the Eighth Circuit have to follow the rules that the Eighth Circuit sets out. So the question of what rights do prisoners have is at the heart of determining whether or not any rights have been violated. So earlier we discussed 3 tests, and those tests are going to be central to determining if those rights have been violated. So the first one that we kind of hint at here on this screen is the deliberate indifference test. So I guess before we get there, though, we should start with the Eighth Amendment, which is the basis for a lot of the deliberate indifference claims. The Eighth Amendment reads, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted." The cruel and unusual punishment inflicted here is the primary one that we look at when we're looking at prison litigation. The Eighth Amendment has been incorporated and applies to the states through the 14th Amendment. While the Eighth Amendment may have originally prohibited only actual torture, in the modern world it encompasses broad and idealistic concepts of dignity, civilized standards, and humanity and decency. So the easy cases to identify are ones in which harm is intentionally inflicted. These would be torture cases, cases where inmates are forced to fight by guards. Those are pretty clearly violations of the Eighth Amendment standard here against cruel and unusual punishment. The more difficult ones are the not clear harm that's been inflicted, or the more indeliberate or indifferent-based claims. So inmates retain all rights that are completely consistent with incarceration, but lose others to the degree such rights are inconsistent with incarceration. This is going to be especially important when we talk about the Turner test later on. That test covers most of the constitutional rights that somebody has, whether or not they're in jail. And those rights do still apply so long as they're consistent with the incarceration. The right to not be discriminated against on the basis of race is fully compatible with incarceration, and prison discrimination cases are considered under strict scrutiny like any other discrimination. So that is an example of the Turner test, which we will get to in a minute. But before we do that, I'd like to talk about the deliberate indifference test a bit more. The deliberate indifference test is solely focused on the Eighth Amendment, and as such is very directly related to the right against cruel and unusual punishment. So the deliberate indifference test is, the Eighth Circuit has said the deliberate indifference test is a prison official cannot be found liable under the Eighth Amendment for denying an inmate humane conditions of confinement unless the official knows of and disregards an excessive risk to inmate health or safety. The official must both be aware of the facts from which the inference could be drawn that a substantial risk or serious harm exists, and he must also draw the inference. The Eighth Amendment does not outlaw cruel and unusual conditions. It outlaws cruel and unusual punishment. The way that this generally has presented itself in the Eighth Circuit is in medical indifference claims, or claims of a deliberate indifference to a serious medical condition. For that to occur, you need to establish, one, that there was a serious medical condition, two, that the prison official actually knew of that serious medical condition, and 3, that they deliberately disregarded that condition. Now, the first condition, whether a serious medical need arises, the Eighth Circuit has a pretty open understanding to that. There are cases where a swollen knee, which made it difficult to walk, was considered a serious enough medical concern to warrant the deliberate indifference claim. So any sort of injury or illness which is established by the medical community is likely to meet this first condition. The next condition is that the prison officials actually knew of or should have known. There are cases where a condition is so obvious that the officers cannot say that they did not know of any such injury. Any time where somebody's bleeding, somebody's fainting, the idea that the prison officials knew of the injury is fairly obvious. The final one is that the prison officials actually knew but deliberately disregarded these needs is a tougher one to manage, to hit. So the Eighth Circuit has said the plaintiff must show more than negligence, even more than gross negligence. In these cases, the official has to have deliberately disregarded any injury that was occurring. So the way that this usually breaks down in injury cases is we have complaints that can likely be brought against 2 types of individuals: prison guards and medical personnel. The claims against prison guards, the evidence that they did not disregard a condition is fairly simple. If the prison guard sent the person to a doctor, there's probably not much of a claim that can be made against the guard. The guard's duty in that situation is to have the person see a doctor. Once they have seen a doctor, the claim can likely be brought against the doctor or nurse or whatever medical personnel that they have, but probably not against a particular guard. Bringing a claim against medical personnel is also difficult. Again, the court has said that they have to show more than negligence or gross negligence and mere disagreement with treatment decisions. There was a case in the Eighth Circuit called Bella Court where the court held that the doctor's actions in that case did not amount to deliberate indifference, even though the doctor misdiagnosed the prisoner, the method of physical examination and treatment did not follow community standards, and he disregarded the prisoner's suggested course of treatment. So that was a 1993 case that shows really how difficult it is to meet this standard, even when it's a medical official once they have seen a doctor. Furthermore, there's a reasonableness requirement in this deliberate indifference claim. The officer or the personnel must act reasonably in the situation given. So if getting greater help was not a possibility, the officers are not required to do so. For deliberate indifference claims, or really any claim that comes through a prison, the prisoner must go through the grievance process and fully exhaust that process before bringing the claim to the court system. So that's another hurdle that often needs to be jumped over. Moving on to the next standard, we have the Turner test. The Turner test here is designed to cover constitutional rights that are not Eighth Amendment based for the most part. So the inmates do not give up their First Amendment rights. They do give up their Second Amendment rights, but that will fall under the strict scrutiny test here. The Turner test is very similar to the strict scrutiny test in that it says that a claim must be a valid rational connection between the regulation and the governmental interest used to justify it. Secondly, a court must consider whether alternative means of exercising the right remain open to the inmates. Thirdly, a court must weigh the impact accommodation of the right will have on guards and other inmates. And finally, the presence or absence of ready alternatives to the regulation. So this is a highly deferential standard to the prison system, but it is designed to balance the rights of inmates with the needs of prison system to run a orderly prison. So the valid and rational connection between the regulation and government interest is the first factor here. There has to be some rational basis, some rational connection between why the prison is implementing the regulation and why they're saying they're implementing it. So if there's not that valid rational connection, then the court is going to strike down the regulation under the Turner test. Secondly, the second factor here is the court must consider whether alternative means of exercising the right remain open to the inmates. If the inmates can exercise their constitutional right in some other form that is open and equivalent to what they are claiming the regulation denies them, then the court is going to deny that challenge to the regulation. And finally, the impact that the desired accommodation will have on guards, other inmates, and prison resources, so-called ripple effects, will factor in. This is a balancing test, so the ability for the prison to run itself in a way that is safe for the guards, other inmates, and to maintain prison resources is a factor here. The absence of ready alternatives is a factor that weighs generally in the inmate's best interest. If there are not ready alternatives, simply having an alternative mode to, say, exercise your free speech is not enough. It has to be one that is available for the prison to justify a regulation that denies that ability. So this is mostly First Amendment issues. There are potential other constitutional rights that could be wrapped up into this, though. So our next test that we're going to talk about is, I'd like to just take a minute to discuss the substantive due process. This is known as the shocks the conscience test. If something happens in the prison that is depriving of unenumerated rights to the point that it shocks the conscience, there is a potential claim there. You'll usually know this because of the shocking nature of the facts of that case. Negligence can never pass the shocks the conscience test. It always has to be more than negligence. and due process does not guarantee a constitutional protection for every governmental harm. So simply having a harm caused by the government is not enough for this shocks the conscience test. We also have procedural due process issues. This is a little more complicated. We have liberty issues, the right to life, liberty, and the pursuit of happiness. The liberty issues at stake are often granted from the federal government or the state government. When these liberty interests are touched upon, they often create a right for the prisoner. So such an example of this liberty interest would be a right to not serve a sentence longer than the court ordered. If the court orders a sentence no greater than 3 years, the state cannot keep a prisoner for greater than 3 years. That's an example of a state-created liberty interest that person has. There is, however, no interest in serving less of a sentence. Probation is a system that the state has created, but probation does not create a liberty interest. It is not a guarantee that prisoners can be released on probation just because they have the ability to be. One way that a state law or policy can create a liberty interest is by subjecting inmates to hardships that are atypical and significant in relation to the ordinary incidents of prison life. Some examples here, 30 days in administrative segregation would not count as a significant enough difference in the day-to-day life of a prisoner to allow for a lawsuit to be brought on procedural due process grounds. However, an indefinite time in a supermax unit is a substantial and significant change in that process that would allow for a procedural due process hearing. So this procedural due process has a 3-factor balancing test. A court will weigh the interests that will be affected by the state action. Second, the risk of an erroneous deprivation of this interest and the probable value of any additional or substitute procedures must be weighed. And finally, the government's interest must be taken into account, including the fiscal and administrative burdens that the additional procedures might entail. So the courts are going to look at what is the interest that the person is losing out on, what is the chance that they are losing out on those rights erroneously, and finally, what the government's interest. This is a balancing test as well. The cost of more hearings may be enough to not allow a due process claim here if the right infringed upon is low. So an example here where the federal government has created a liberty interest is the ADA, the American with Disabilities Act. That is very much in place still for people in prisons. The prisoners still have the ability or the right to have equal access to different programs and access to the outside time that other prisoners are allowed to have. So here we see primary causes of these actions. We've talked about some of these. When you see physical and mental health care issues, housing inmates and with mental illness and isolation, those can cause these issues. Other types of areas where these claims might be brought are restraints, safety, excessive force, noise, ventilation, Religion is often an area where civil rights litigation in prisons is fairly successful. Food quality. Law libraries is one where civil rights litigation is not that successful generally. The prisoners do have access to or access to the courts, but that does not mean they're required to have access to law libraries. Access to the mail system is another area where prisoners do not have a whole lot of rights. So these are the primary causes of violations to constitutional rights. The secondary causes here are things that will cause primary cause violations. So we have segregation and solitary confinement. On its own is not a violation of constitutional rights. However, segregation and solitary confinement can often lead to ignoring health issues, not properly being fed, those kinds of things. Same with lockdowns, overcrowding, exercise. Oftentimes, inmates will have conditions where they need to get a certain amount of exercise a day. If they are not given exercise, then they are not able to properly address those conditions that can lead to a deliberate indifference claim. Areas where no cause of action exists would be rehabilitation and programming, parole issues, as I mentioned before. Prisoners do not have a right to parole. Regulations and expert opinions. What that means is that when the state comes up with prison regulations, when experts come up with how prisons are supposed to run, that they're not creating a cause of action by doing so. Those are considered best practices, but not liberty interests. Violations of those regulations and expert opinions usually will result in no cause of action. So, to wrap up the prison litigation section here, we have prisoners do have constitutional rights that cannot be violated by the prison. Turner test is a deferential standard designed to balance these rights with the rights that the prison system has when considering the prison regulations and whether or not they should curtail certain rights. The primary and secondary causes of action when filing a complaint on behalf of the prisoners are that list that we went through. It's important to look out for those primary causes because that's usually where constitutional violations will come into play. And finally, the Eighth Circuit regularly handles claims of prisoners. Again, the Eighth Circuit will either determine the rules or actually take up appeals when these issues are brought to the district courts. So to wrap up the whole summary, the Eighth Circuit is the Court of Appeals for a good chunk of the middle of the country here. It is located in St. Louis, Missouri, primarily. The Court of Appeals hears challenges to district court decisions from courts located within its circuit, as well as appeals from decisions of federal administrative agencies and specific laws and regulations in the Eighth Circuit that are important are particularly prison litigation here. Thank you.